Hello folks, and welcome once again to Steele Law Office. This is my video blog, and I often address some of the frequent legal topics that come up in my area of practice. Today we're going to talk about independent legal advice for domestic contracts. What does this mean in simple terms? If you are entering into a marriage contract, a prenup or a postnup, as they say in the US, or if you are signing a separation agreement or cohabitation agreement, or a sperm donor or egg donor or surrogacy agreement, you really need to obtain independent legal advice. So people ask me, can one lawyer represent both parties in a separation agreement or a marriage contract, for example? The answer to that question is yes, anything is possible, but it is not recommended. In fact, it would be a very bad decision on the part of that lawyer to assume joint representation of parties that are, at least in theory, opposite in interest. Now, that can also be a ground for setting aside a marriage contract or a cohabitation agreement in the future, and no one wants that. Why spend money on drafting a document that may not be worth the paper that it's written on? There are several grounds that courts can use to set aside a domestic contract. If you hide assets from your spouse in financial disclosures, if the contract is very one-sided or unconscionable, and most importantly, for the purposes of this discussion, if one of the parties can show that they didn't understand really what they were signing, that's where independent legal advice comes into play. One lawyer will always draft a contract, and the other lawyer, who represents the second party, will review independently the terms of that contract with their client, explain the law, explain how the contract changes the law, and make sure that this person knows precisely what they're signing. Having independent legal advice for both parties ensures the contract's validity, and it is in both parties' best interest. Now, the price of independent legal advice should, and I say should because they vary by lawyer, be less than the price for drafting a contract. It's usually a flat fee, in my case, unless further negotiations are required, and you may or may not choose to waive your financial disclosures in the agreement. Now, if we switch just a little bit to assisted human reproduction context, such as surrogacy, egg donor, or sperm donor agreements, those also benefit greatly from independent legal advice. While these contracts do not have a lot of case law behind them, it is still a wise idea to have a donor, let's say, as well as the intended parents have separate set of lawyers, so that in the future, if things get contested, at the very least, the intention of both parties is clear, and none of them can claim that they did not understand the state of the law at that moment in time and how it applied to them. Those contracts are different, however, from marriage contracts and separation agreements and cohabitation agreements, because the best interest of the child that is born through assisted human reproduction process is always subject to the court's jurisdiction. So whether or not you can prospectively contract out of those rights and responsibilities still remains a relatively unsettled issue in Canadian law. I hope that this overview has been helpful, and if you require any assistance, I'm here for you. This is Steele, and stay well.